Good morning, and may it please the Court. The Court of Appeals ruling below dramatically departs from this Court's precedents, and if it were affirmed, it would severely inhibit K-12 students across the state from alerting authorities to sexual harassment occurring in our public schools, or providing evidence in connection with such mandatory investigations, adjudicatory investigations, for fear of being sued, just as happened here. But that is not the law, and nor should it be. As the amicus brief of the Attorney General points out, the reason why absolute privilege is extended to all participants in quasi-judicial government proceedings, such as the formal Title IX investigation here, is the societal interest in encouraging people to come forward and speak freely. First, to trigger important governmental investigations, including licensing of child care facilities, etc., and in reaching the appropriate decision. And fundamentally, the Court of Appeals erred in conflating two very distinct legal issues. First, the nature of the governmental decision, and second, which procedures were used in rendering that decision. This Court has held time and time again that is, quote, it is the nature of the decision rendered by the governmental body that is the predominant consideration in determining whether the governmental body has exercised a quasi-judicial function. And a quasi-judicial function, as this Court has also held numerous times, is when the government applies a set of conduct or code to a particular set of facts developed and determines a decision here by preponderance of the evidence that affects specific individuals.
Can I ask you about that, Mr. Zansberg, and good morning to you. On the standard, you just quoted effectively Cherry Hills, which we followed in Huffler. Can I ask you, how do we reconcile Huffler, which followed Cherry Hills 106A4 standard, and Churchill, which, at least in a footnote, suggested in public officials' immunity that there's a different standard? How do we reconcile those?
Very easily, Your Honor. Churchill's decided under federal law. The Colorado common law of absolute privilege had no application there. It's entirely irrelevant to the Court's consideration here.
Churchill seemed in that footnote 14 to draw a distinction, obviously, on which the division relied. I don't know that it's fair to say that that footnote simply can be ignored, in a sense, by saying, well, Churchill's about federal law. I mean, it seems to draw the very distinction that the division relied on in saying that 106A4 and absolute immunity should be looked at differently.
With all due respect, Your Honor, it wasn't just one footnote. It's both footnote 7 and footnote 14. And in that, this Court made very clear that it was deciding the question, and it parted from the Court of Appeals below that did look at Colorado common law under 106.4, and this Court made clear that that law was not applicable because this was a Section 1983 case, and Section 1983 state law cannot immunize government officials from claims under Section 1983, and that's why federal law does not immunize school board members from exercise, does not apply qualified, does not extend absolute privilege to school board members when they exercise discipline. That's the holding of the United States Supreme Court in Strickland. And for the same reason, the federal cases cited by the petitioner, by the respondent, and relied upon by this Court in Churchill do not apply when state court tort claims, state law tort claims are at issue. So only state common law applies.
Mr. Zansberg, I just want to make sure I'm understanding you correctly. Is the language on which I'm focusing in footnote 14, I don't remember 7, I apologize, but 14, is that gratuitous then? Is it just sort of dictum? Is that?
Well, I think footnote 14 does say that we have defined the term quasi-judicial more broadly to define the scope of Rule 106.4 than federal courts have to determine when absolute immunity applies under federal law. Footnote 7 makes even clearer, if you'll allow me 1 second. Footnote 7 concludes, also referring to quasi-judicial immunity under 106.4, or what is quasi-judicial, not immunity, and concludes, accordingly, we resolve the question of absolute immunity based only on federal law. See note 14. So because Howlett versus Roe says state common law cannot provide any immunity against a claim for Section 1983, with all due respect, Churchill has no bearing whatsoever on this case. It's an application of federal immunity law. And as I said, under federal immunity law, in contrast to this court's holding in Mason, parole officials are not entitled to absolute immunity either. They're entitled to qualified immunity. And numerous governmental officials, for violating the constitutional rights under section, or claims alleging violation of constitutional rights, are entitled only to qualified immunity. But here, there are no federal claims.
Oh, and also, Mr. Ginsburg, I think you make an important point.
Justice, could you pull the mic neck closer?
Oh, sorry. Yes, sorry. You make an important point there as well, I think, when you point out that in Churchill what they're dealing with is whether the officials conducting the investigation are subject to suit, or whether they in fact have immunity. And that's a very different question from the question of whether someone testifying in a proceeding can be sued for what they say in that proceeding. So when you're trying to decide whether a proceeding is quasi-judicial for the purpose of determining whether someone testifying in that proceeding can feel safe testifying because they won't be sued later for the things they said in that proceeding, that is, they have absolute immunity, that is safety from tort suits. It's not immunity from suit for their actions as officials, which is what we were dealing with in Churchill. Those are two really, really different questions. And so then that's the difference between Section 1983 and immunity in Section 1983 and everything that Churchill is talking about, and what we have talked about in Cherry Hills and our absolute immunity cases talking about defamation and quasi-judicial suits. And those are, we just, I think, need to be very careful not to entangle those two things.
I agree. I'm not sure there's a question, but I do completely agree. But the confusion between, and the words immunity, absolute immunity versus absolute privilege. Yes, we're talking about an absolute privilege for statements made in connection with quasi-judicial decisions, as opposed to the immunity that governmental officials exercise or are entitled to when they exercise such authority. But Stepanek and all of the case law says that if a governmental decision is quasi-judicial in nature, then two things flow from that. One, there's a right of judicial review under 106A4, and that's why this court has applied the same test in two cases that weren't even acknowledged in the respondent's brief, Sternholm and I'm forgetting which two weren't acknowledged, but I believe Sternholm and Mason. And Mason was more in the line of immunity than privilege. But in both of those cases, this court applied the same determination of what is a quasi-judicial decision in nature under Cherry Hills to determine whether or not immunity or privilege applies. Stepanek makes clear, as does case law elsewhere, that if a proceeding is if in the nature of quasi-judicial decision-making, then all participants in it, not just the decision makers, but all participants in it, the witnesses, the attorneys, the parties, anyone participating or rendering any type of statement that is pertinent to that proceeding is entitled to absolute privilege. So yes, the words immunity and privilege are used differently, but here we're talking about an absolute privilege under Colorado common law that extends to all statements made by participants in quasi-judicial proceedings. And the fact that, so the two things that flow from determining a proceeding is quasi-judicial in nature, one is the right to judicial review, actual judicial review, and two is the right to due process. There is no right to due process for other than quasi-judicial decisions of the government. And so what the mistake below was to confuse those two issues. As I said, the nature of a governmental decision determines whether due process applies, but the lack of due process plays no role in determining whether or not the nature of the decision was quasi-judicial.
So let me just clarify, and I think I'm with you. I'm tracking what you're arguing. The point you're making here is the setup that the district had was a quasi-judicial proceeding. There are all the procedures that provided for judicial review and the like, and what the division below's concern was more about whether those procedures actually were applied in this case, or whether there was a due process violation. So I guess your position is that the respondent here's claim is really not one about quasi-judicial, the nature of the proceeding, but whether he was afforded due process, and those are different issues. That's what you're saying?
Absolutely. And in fact, this court and the Court of Appeals below, on numerous occasions, has found that certain governmental decisions were quasi-judicial in nature, giving rise to judicial review, and yet held that due process had been denied, invalidating the quasi-judicial decision. That happens routinely. And by analogy, it would be true in a judicial proceeding, too. Today's proceeding is not under oath. There's no cross-examination. A trial judge can dismiss a case on papers alone, no trial-like procedures whatsoever, and in doing so can deny due process. And on judicial review, that decision would be reversed. But it doesn't negate the fact or vitiate in any way the fact that it was a judicial proceeding. And that's exactly whether it doesn't change the nature of the underlying proceeding, and that's true whether it's an actual judge or a government exercising quasi-judicial authority.
So, Mr. Zansberg, I understand what you're saying, and you may very well be right on the law, right? Brings a smile to your face, right?
Yeah.
But obviously what the division was struggling with in part was what it perceived as sort of competing policy concerns, right? The division seemed to be struggling a bit with what it viewed as competing policy concerns, right? On the one hand, as you've emphasized, we want victims of sexual assault, sexual harassment to be able to come forward without fear of being sued for defamation. On the other hand, the division's saying, well, we also want to create a legal regime in which there is sufficient due process that someone who's been falsely accused doesn't suffer consequences that they shouldn't, And I understand you're saying they're getting the cart ahead of the horse here in a sense, right? But are those, is the division right to at least be concerned about those competing policy issues and try to reconcile them in a way? But what do you think?
Well, I think there are two good reasons not to adopt a different standard for what is quasi-judicial decision-making for purposes of 106.4a, judicial review, actual judicial review, and for purposes of extending absolute privilege to everyone participating and statements made in connection with those. One is that this court has never done so. On 4 occasions, it has applied the exact same. So there's following precedent. Court need not do so, but generally it should. Secondly, the policy reasons for having the same standard and test is it would be quite difficult, illogical, and confusing to have a proceeding deemed quasi-judicial for purposes of giving rise to judicial review and to the right to due process, but to have it be not quasi-judicial for purposes of extending absolute immunity to everyone who participated in that.
Absolute privilege.
Absolute privilege. Thank
I
you.
really think it's important to keep. But you're not answering Justice Hood's question. The division was quite reasonably concerned, I think, and I guess I'll just say, I think the division was quite reasonably concerned about the fact that there weren't very many procedural safeguards here. Even if we conclude, or one concludes that this is a quasi-judicial proceeding, there didn't seem to be a lot of due process. So if this case, say the Title VII investigation had come out the other way, ultimately, Title IX, sorry.
It's all right.
I used to teach employment discrimination. My head's in Title VII. What recourse would Mr. Gonzales have had?
He had many recourse. He did, and he did, obtain a reversal of that initial finding by a preponderance of the evidence. He also filed suit in federal court alleging his due process rights were violated, and he could have sought judicial review in state court.
Of the Title IX, of the conclusions of the Title IX investigation.
Yeah, in Nichols versus DeStefano, the Court of Appeals accepted for under 106A4 a decision for review, the Jefferson County School Board's expulsion of a 10th grader, found that it was a quasi-judicial determination subject to judicial review, and upon review found that the student had been denied due process, that the student's expulsion violated her rights under due process, and so it was remanded for further proceedings consistent with it, to have a new determination. And it was affirmed by this court on a 4-4 non-vote, essentially. But that shows that the fact that a student can obtain judicial review for a final determination of a quasi-judicial nature, as here, renders it quasi-judicial. And all of the participants in both in the Jeffco case, Nichols versus DeStefano, and here are entitled to absolute immunity from tort claims. Now, they're not entitled to absolute immunity for Section 1983 claims. The decision makers, the governmental actors, because obviously the witnesses and others may not be acting under color of state law. But that's the difference between state law and federal law. And it would be nonsensical to subject the parties involved, the witnesses and others, in such quasi-judicial proceedings to have to defend lawsuits such as this one. It would basically render Title IX ineffective. If people who are going to avail themselves of the right that Title IX provides them, not just the complainants, and again, these were not the statements that gave rise to the investigation. These were statements in the middle of an investigation that was ongoing to determine, based upon the facts elicited, based upon a preponderance of the evidence, whether or not a finding, an adjudication, as the DOE describes this process, an adjudicatory process, they would never participate. If Title IX cannot fulfill its intended purposes, if Title IX cannot fulfill its intended purposes, if the individuals are afraid to avail themselves of its protections. If there's no other questions at this time, I will reserve the remainder of my time for rebuttal.
You may.
Thank you.
Good morning. May it please the court, we are here to ask that the court affirm what the Court of Appeals found, which what quite frankly is that the absolute privilege requires, the application of absolute privilege requires a higher standard of procedural safeguards to protect against malicious falsehoods. It is apparent to me in reading both the pleadings that come before this court, but quite frankly, I was there from day one, having read the record. The facts of this case matter. The facts are essential in this court's determination. Counsel would have you believe that if this court were to send out a chilling effect of all Title IX proceedings and all of those hearings, if they were found to be non-quasi-judicial in nature, it is simply not the case. In this circumstance, what occurred in Jefferson County, Colorado, Evergreen High School in 2018 was nothing short of a farce.
Well, let me jump in and ask you to, I'll start where I started with Mr. Sandberg, and I should have said good morning first to you. Help us with the legal standard here. I would assume you're going to tell me Churchill is the right standard, and I guess I would ask you to respond to Mr. Zandsberg's argument. It is true that in all the cases of absolute immunity in a case like this, we have applied the 106A4 standard as far as I could see. So help us, give us your view of what is the standard for a quasi-judicial proceeding.
You're right. The standard for the quasi-judicial proceeding is certainly, there is the two-pronged test. However, it is essential in the Churchill finding, as within all of the Colorado case law, if one looks at the facts and the actual procedures, that there are robust procedural safeguards, that some process occurs where there is the opportunity to respond in a meaningful manner, that the legal standard must be a heightened review when distinguishing between just what is quasi-judicial and the application of that privilege.
So let me, if I may interrupt, just you said the two-pronged standard, that would be the 106A4 standard applying legal standards to facts. So why, and I hear your argument on the issues with the procedures here. Why isn't that a claim that your client was denied due process as opposed to a claim that this was not a quasi-judicial proceeding? And where do you draw the line between those?
Quite frankly, because the nature of this proceeding involved, and I will just draw the court's attention that for example, what the petitioners in this matter would have you believe is that there was this thorough investigation. But none of that, the interviews of parties, written statements, discussion that there was back and forth, that they were subject to some examination, that the veracity was tested, none of those things occurred at all.
Sure, but again, that seems to me to be a challenge to how they enforce them. And I've got the procedures here.
Right.
I mean, there's a whole bunch of procedures where there are calls for written statements. You can comment on each other's statements. You can provide questions that you want the investigator to ask the other side and the like. That may not have happened here, but those are the procedures that were in place. And so I'm still having trouble figuring out where the line is between your argument that your client was denied due process and the fact this was not set up to be a quasi-judicial hearing with judicial review and the like.
Well, first and foremost, for example, in 2018, the Title IX policies were not published and or available. And so in terms of process in and of itself. And so the due process argument is difficult, at least at the time, and again, I go back to 2018, I was the attorney trying to manage this case, so I lived it. There were no procedures, there were no protocols, there were no methods of applying, there was no statement of you may do A, they may do B, and while that may be a due process argument as well, there was nothing within the scope of chatting with a school principal. And let's not conflate, which the petitioners have done in this matter. They've conflated the law enforcement investigation with the first 2018 investigation with the reopening of the 2020 investigation. They have confused some of the parties to that work. And those simply were not things that occurred. And there is nothing, again, the quasi-judicial standard, I will tell this court, I've read every one of these cases 10 times over, Nothing that occurred in any of these cases, in Witter, in Hoffler, in Cherry Hills, in Churchill, in smacks of what occurred here.
Counsel?
This was the loosest of procedures. It was, tell us what you think happened, and
Counsel,
we'll make a decision.
I'm sorry. I just want to make sure I understand where you are. I think I hear you in responding to Justice Gabriel acknowledge that the test that this court has applied is consistent with Cherry Hills, Hofler, and that's the test, but that what happened here is that your client was not afforded due process because there were all these sloppy procedures. Is that what you're basically arguing?
Well, if the test is just the two-pronged test, are the rights of individuals involved, and a decision is made, it is difficult to argue that that is not what should have occurred, but that there were rights of individuals involved. I think the question then becomes, is the method by which this particular proceeding.
Right, and you're saying your client was not afforded due process, going to Justice Gabriel's question.
Correct, but again, the robust requirements of stringent procedural safeguards, those guardrails that would indicate that this is quasi-judicial in nature. We're not even talking about fairness, fundamental fairness, or the right to cross-examine or a hearing specifically, although those did not occur as outlined in Hoffler. But there were no safeguards whatsoever. These were informal chats. Ultimately, we got to submit some written statements, but there were no investigations, no interviews, no neutral third parties. There were not even multiple parties decision-making at the time.
May I ask you as a factual matter, Ms. Palou, what we're talking about here in this case now is the second investigation, right, the reopened investigation?
To be clear, and I think this is extremely important, there is a cursory investigation. The decision was made in approximately 3 weeks by the school principal, not the school resource officer. And some of those interviews and part of that criminal prosecution and that evidence and data is referenced as if that occurred during the Title IX investigation.
Which one?
Not true.
The reopened or the original?
They're the same. And I'll say
Okay.
because we have an investigation that is, as again, informal chats with handwritten paragraph statements from students without any advisement as to what's going on, and withholding of factual accusations. So my client was said, some kids are complaining about you. Can you tell us why you think they might be?
Yeah, but and again, I'm trying to get us focused here. The
And I
statements
will,
at
Your Honor.
issue are related to the reopened investigation, don't they?
They reopened the same original investigation.
And the statements at issue related, that's the defamatory claims we're talking about in this case.
There's some pause in between the reopening and the original conclusion of October of 2018, the reopening in 2020.
Right.
They reopened that same investigation and again are asked to could you send us a written statement?
Sure, and the allegations we're talking about here, the defamatory statements that are alleged related to the reopened investigation, do they not? And I may have the facts wrong, that's why I'm asking.
Well, the defamatory statements, quite frankly, were made at the very beginning. They were the fundamental basis for the reason my client was charged. They started at the very beginning and were proven demonstrably false during the criminal prosecution. They then resurfaced and expanded, having removed some of the original allegations. Ms. Weary, for example, testified at length for hours about an event that was later proven to have not occurred whatsoever. Fortunately for Mr. Gonzales, I had the criminal transcripts. Who would think that a 15-year-old boy would be lucky to be charged with a sexually related crime, not sexual assault for these petitioners, which is referenced again in the petition, but that he was charged, and I was able to bring in 14 to 18 witnesses named by the accusers at the time, and we had transcripts finally of actual interviews and cross-examination and due inquiry into the veracity of these statements. That is what that reopened investigation referred on, were the transcripts and actual interviews conducted, quite frankly, in a courtroom. My point is that there is nothing, again, writing a letter to a school district official, and this is our argument, it cannot be quasi-judicial.
All right, so here's where, let me interrupt. Here's where I have concern. And again, I'm not hearing clearly what the statements are at issue here, but I think they related to the reopening. And one issue here is the school district asked these women to supplement their allegations, and then your client has sued them. I'm concerned about that. They're conducting an investigation. They ask the other side, please supplement what you've done. They're complying with an investigation, and then they get sued for defamation about it. That seems to me the exact kind of thing where we would want immunity to apply, because we want to encourage people to come forth and participate in investigations. That's why I was trying to get you focused on which statements we were talking about.
I wholeheartedly agree with this court. And if those accusations and if those statements are truthful and reliable, then that is exactly what should be protected.
But
that is
I think
that's what we all want.
I'm sorry. I think Justice Gabriel's point about the importance of having privilege for those statements is that when you say if they're reliable, then they should be protected, then you're saying they shouldn't have privilege. You're saying we should be able to go in and investigate whether they're reliable. And I think the point that he's making, and I'm sorry to speak for you, but a point I would like to make is that in a quasi-judicial proceeding, the reason that we might have privilege for a quasi-judicial proceeding is so that people can feel free to say things that then don't come under cross-examination in a defamation suit. They are not scared then that they're going to get sued in tort for the things they said later. They should come under cross-examination. That's a due process question. They should come under proper procedural, there should be proper process in that quasi-judicial arena, but they shouldn't fear that because of what they're doing in the quasi-judicial arena, they're going to end up sued in tort later.
And I guess I would ask.
And when you say if they're reliable, they should be protected. I think that's the concern.
And I guess my question to this court, quite frankly, is why not? If you go before an administrative process, a body, a quasi-judicial proceeding, a school administrator, a school principal, and you lie, and then you double down on the lie, and then once it's been proven in a court of law that you have lied, you get to go back and lie some more with some edits. That is the problem, and that is what we are asking this court to look at, because that is exactly what happened.
Well, let me take out the lie, and I understand and fully respect your position, but take out the extreme, a lie. Anybody could always challenge whether the statements were accurate or true or whatever else, and they would subject somebody to a lawsuit. And Justice Hart was making exactly the point that I was making. We are agreeing. That's the problem. So it's not why can they just lie. The fact that why do we want to subject someone to a lawsuit challenging whether they were lying or they were accurate or the like? That would certainly chill somebody's willingness to participate in an investigation or to come forward with allegations that for them were very serious, wouldn't it?
Well, Your Honor, my question would be, isn't that what we want? We certainly don't want. And as you look at this full body of case law, malicious statements, things that challenge, I was looking at Witter yesterday, and it says, courts may review a record, but the record lacking any competent evidence means the ultimate decision of the administrative body so devoid of evidentiary support, it can only be arbitrary and capricious. My question is, how slippery should this slope become? Where someone, a young woman, a teenager, and a gaggle of friends can go in and spin a story. And the court's asking me, well, shouldn't we allow some of these fabrications, lies, exaggerations, whatever, and I'll be generous in this because these are just undisputed and unrefutable lies. All of the named witnesses to what had occurred to these women refuted them directly, refuted them in absolute. They were said so-and-so saw it happen. Person was finally cross-examined. No, I did not see a thing like that. So do we want to protect under an umbrella of, I understand public policy, I understand Title IX, and absolutely a victim of sexual assault should be free to come forward. without fear of collateral obligation. But the other issue that counsel has relied on is, well, Mr. Gonzales has other recourse.
Oh, well, that's exactly where I wanted to take you, so it's a good time to jump in. So Mr. Zansberg says, you have other avenues for vindicating your client's interest if he was truly damaged, right? So you can bring suit, and you have. And what's your response to that?
Not. My client's been cut off at the knees at every turn. And I'll tell the court, and perhaps I've been practicing law too long. I think I have. I hope this is one of my last days in a courtroom as I near retirement. But the experience is as follows. The district attorney, who's an elected official, brings cases, and they have a policy statement. We believe victims, right? Or we honor this, or we have a high conviction rate, political office. That district attorney brings a case costing the taxpayers of that county thousands and thousands and thousands of dollars. This was a very lengthy trial, and there were 2 of them. They lose. And they lose handily with 2 bench trials, which quite frankly in Jefferson County, Colorado, doesn't happen very often. Okay? And they lose pretty resoundingly. Findings in both cases were, luckily, we had jurists that were eloquent and detailed in their findings. Mr. Gonzales says, I can prove, and we can, that at least one of these incidents was entirely fabricated, and I mean fabricated, not spun in one direction. There was a lockdown drill that Ms. Weary testified to. It occurred. She remembered my client slipping his feet up her dress to touch her crotch with his toes. She testified what she was wearing, where she was sitting, who was next to her. That lockdown drill never occurred. And from these initial allegations, there was a bit of a peer mentality. There were group texts about let's harm this child, my client. They are 15 and 16-year-olds. I get it. But are we endorsing that you may come forward because it's quasi-judicial in nature and you get to chat, write an informal letter, sign a statement, and that the investigator will look at, well, they said this is what he did to me, and the principal was the original finder of fact. We appealed to an administrator. My client never met with the school attorney, to be clear. His name is not Jeff Krause. He didn't choose to go to Columbine. None of those things happened. He was booked. He was told he would be a mandatory protection order. That was from the school resource office. But these young ladies kept going.
Why did the school district, and good morning,
Yes, good morning.
Why did the school district reopen this investigation? They did that after the court trial, right? And after the judges 2 judges, you said, had found in favor of your client, and in fact had made statements, I think, related to the lack of credibility of the allegations and the folks making the allegations. So why did this come back again for a supplemental?
Well, we had hoped and prayed that at the end of the criminal cases, that would be the conclusion of these proceedings, and that all these children could move forward. Except, so we went and met finally, and this is February actually, of 2020, with the school district saying, what are my client's options regarding walking for graduation, being on site, because there had been protection orders in place. He didn't want to not be at Evergreen. What could or can be done? We're just checking in with counsel. And the answer was, well, he could return to Evergreen if he so chooses, or he could walk, because he did actually have friends there, by the way. This is actually the community he's raised in. He did go K through 12 with the vast majority of the students at Evergreen High School. So when the school district, as I understand it, and again, let's be clear, discovery is not yet complete in this case. I've got redacted emails. I'm not privy yet, because of these SLAPP proceedings, to what really happened. The parents and the girls went crazy, and they emailed and called and called and emailed and emailed and called. And I got a call from the school principal saying, all hell is breaking loose at the mere suggestion your client may walk at graduation. At that point, I said to counsel, take a look at my transcripts from my court proceeding. And again, who would think, thank goodness, we had those, but we did. And they said that he can come back to school. He has been acquitted of all charges. He can come back. Because of the agitation or the request, whichever, I'm a trial lawyer, so I am in my trial mode, of the parents, the school said, well, we'll restart the whole thing all over.
So this wasn't as simple as the school just going back to them on their own and saying, hey, we want supplemental statements. It sounded like
Correct.
there was
Correct.
more to it.
They had decided to rescind their prior findings because of Judge Rappaport's detailed finding of lack of credibility, false occurrences, the knowledge, quite frankly, that the school community liaison was called in to testify the lockdown drill never happened, and that, again, named eyewitnesses repeatedly refuted. So counsel for the school district in February 2020 read a transcript of sworn statements and evidence and documentary evidence and said, we're rescinding this finding. There's just no way.
No, please.
Well, no, I was actually going to take her back to your question about whether Mr. Zansberg was correct, that in fact her client has some kind of remedy.
Go for it.
Can you answer that question, please?
So no, we went to the district attorney who had prosecuted my client and
Oh,
said,
no, I mean the legal remedy.
Like in
No.
the federal court remedy?
pardon me?
The federal court suit, for example?
With regard to Jefferson County? Yes,
Yeah.
yes.
Does your client
Oh,
have
but
the
if and
ability
only-
to file or to pursue or to continue any kind of sort of legal claim other than this?
There's nothing else in practical terms. So the prosecutor, of course, in my opinion, of course, determined that they were not going to turn on their own victims and would not file perjury charges, even though there is no question in my mind as an officer of this court, they would have been found guilty. The district attorney said we will not.
No, but I guess ultimately,
And then-
what about a civil remedy for
This is where we are. There's nothing left.
As a due process claim. Because the issue is a due process claim.
Due process claim against the school district.
Yes.
But the people that raise false allegations and tell falsehoods repeatedly and publish them, not only to this Title IX investigator, but to the entire community, there's nothing left to be done. And that, to me, is the most chilling of all. You talk about chilling conduct. My advice to an adolescent male in a high school would be not to come with 150 yards of a female.
Let me take it in a slightly different direction, if that's okay. I mean, I hear your position is that your client's left without any meaningful recourse, and so here we are. Well, your position is that due process or the lack of it has to inform whether a proceeding is quasi-judicial. That we have to look at that. Are you hearing me? And so my question for you is to what degree of due process? So help us understand what rule you would have us fashion.
If the court looks at Hoffler, for example, which is similar, although again, you have published guidelines, you have employment policies, you have board after board after board, as in with Churchill, right, where they go, there's an ad hoc committee, there's a standing committee, then there's a 7-day hearing, there's 6 months investigations. There should and must be something more than, would you tell me what happened?
Well, that's where I'm trying to go. So how much more, right? So you've emphasized the importance of the trial and getting to the veracity or lack of veracity in this case. Mm-hmm. And so you seem to suggest that in the absence of a hearing and an opportunity for cross-examination and perhaps an opportunity to present your own witnesses, that maybe we don't have the requisite due process. Is that your argument?
Well, I would tell the court that first and foremost, just in 2018, there was no even investigator for this county of Jefferson.
Well, I understand. But looking to other cases, right? So where's the line, I suppose?
There has to be some test of veracity and accuracy. What that test could be detailed and thorough investigation with record of, for example, an interview, an actual formal interview with whomever that may be, with a record. These are the transcripts of this interview, provided then again to both sides. Perhaps independent witnesses inquired of, and I mean independent in terms of you've named these 6 eyewitnesses. The supplemental complaint for the Title IX investigation alleged that the community of Evergreen was on alert from and let's be clear, a sexual predator, a rapist, that nobody could sleep at night, nobody could walk down the street and feel safe with a 16-year-old boy going down the other side of the street.
Well, let me ask you to clarify that. There are two different, you've talked about the trial a number of times. The trial was an allegation of sexual assault, correct?
No. In fact, that's another fact that the
What were the charges in the trial?
Unlawful sexual contact for Alex Weary and Ashley Hushen.
Okay, and the allegations in school were mainly sexual harassment, right?
That was what the school determined when we received the original 2018 Title IX finding, was that he had violated the sexual contact and behavior codes.
Okay, and that would subsume harassment, unwarranted statements and the like.
Not
what
in
I'm
my
trying to
opinion
get
as
to,
a criminal defense attorney, but perhaps in a
Right.
global civil umbrella of, hey, I'm the principal, sure.
Well, it's relevant here because you said, all the witnesses lied. I mean, there's one thing about saying they lied about being touched improperly and a different thing about whether they lied about being harassed. That's what I'm trying to get to.
Well, and I will tell the court that the transcripts reveal that Ms. Hushen stated she wasn't really even sure what had happened and if she should be upset. And that she wasn't really sure that my client had ever attempted to touch her or intimidate her at all. I mean, this is quite an aberration, and that is why I feel I focus on the facts, because it is an aberration. It is, I suspect, a peer mob mentality. And I think perhaps an autistic kid who's a 15-year-old adolescent male who was violating some social norms or boundaries. But the evidence is that he kind of creeped them out. And that was about it. And in terms of when we looked at the dates that these things occurred, the opportunities for the dates to occur, the number of possible contacts between my client and the accusers, there were 2 to 3 possible times where something could have possibly occurred.
So the answer to my question, I believe, is, maybe we don't have to craft a rule that would apply in all circumstances, but whatever degree of due process needs to be afforded to make this quasi-judicial, it's certainly more than what happened here. That's sort of what I hear you saying.
Clearly, and going forward, from what I understand, and even frankly from the 2020 investigation, it looks to me that Jeffco, and again, this is something I think the petitioners discount, why not just have the school district learn a lesson and create a more formalized process? If you look at the degree to which the Department of Corrections and Hoffler went, even
So let me jump in and ask about that. How do you read Hoffler as supporting you, or do you read Hoffler as just applying the Cherry Hill standard, the 106A4?
I read it as supporting me because if you look at the procedures, safeguards that were afforded Hoffler, there were quite a number. She did get a hearing. She went before not one but 2 boards. She had an employment contract. There were outlined, written, published procedures. Make no mistake, the publication that petitioners refer to in 23 was not published and was not made available to my client or any of the students in 2018.
So is Hoffler Cherry Hills plus or 106A4 plus? What's Hoffler then? Or is it just a 106A4 case?
Well, certainly the fact pattern is not analogous. I think that the findings regarding in the definition of quasi-judicial provide some direction as to what we should be looking for, which is, again, take it whichever direction. Would we want a governing body, perhaps more than one individual investigator, to get some written statements and make a decision? And that is not what happened in any of these other cases. Was you write me and tell me what you think happened. You write me and tell me what you think happened. And then I'm going to take a good look at that and decide who I find more credible.
If we apply the standard that we've applied in the past for purposes of Rule 106A4, do you lose?
No, I don't. And I actually wrote it out. An administration official or executive official acts, determination of rights, present existing legal standards, or policy considerations. The policy consideration I would submit to this court or any court in this country, we cannot endorse and suborn malicious, false statements being presented to any body, an administrative hearing judge, an adjudicatory hearing, an appellate proceeding. Are we going to allow people to come in and lie at will with no real recourse?
So time is very limited now. Let me just ask you this. One of the things that troubles me in this case is that you have the alleged victims. I understand your client was acquitted at the criminal trial. but who've come forward, and they don't have any control over the process, right? They provide information within the parameters of the process that exists. And so they're then sued for defamation, in a sense, for the sins of the government, right? Should we be concerned about that at all? You know, that they're being held accountable. You're going to tell me, they're being held accountable for falsehoods, but they don't have control over the process, is my concern.
No, but if I were to go into as an officer of the court as to, for example, a chief judicial officer in my district where I practice, do I get to walk in and say, hey, you know what? Counsel just brushed up against me in the hallway and he's been harassing me for years. None of those things are true, but it is somewhat official, and the judge gets to say, well, I'm going to see what I'm going to do about that. Not the case. We go to a dirt attorney rig. The voters of Colorado just approved a judicial performance and disciplinary body. There are bodies, regulations, publications, rules, procedures, neutrality, and investigation. It has to be incumbent upon a reporting party to tell the truth. Criminally, we have false reporting options. Criminally, perhaps perjury, but that is at the discretion of the person filing the case, the prosecution.
So,
civilly, we have, if my client's cut off here, he has absolutely nothing he can do to, one, stop the statements from coming, because they keep coming, which is why we got back here. And two, he has no control over whether perjury charge is filed. Three, he can only sue the school district to some degree. Where does he go when somebody lies about something so egregious, so harming, so damaging mentally, emotionally, reputationally?
I'm gonna need to stop. Let me just follow up briefly, though. I mean, if I'm understanding you correctly, what you're saying is that they need to lose privilege, these young women, in order to maybe serve as a catalyst for systemic reform to make the due process more robust in this context. So they have to lose privilege and potentially be subject to damages in order to invite reform systemically. Is that essentially where you're coming from? As to these policy considerations?
I don't know that it's reform.
Briefly, too, yeah.
I'm sorry. I don't know that it's reform. I think it's definition. So Jefferson County needed to define better what they were doing. But the movements here are trying to safeguard themselves from legal exposure. They have absolutely no legal exposure whatsoever for saying something that is untrue. And that is what the court's going to have to decide. Are we narrowing what is provided by absolute immunity or expanding on that? And truthfulness, I would suggest, should be at the heart of this analysis.
Thank you.
Thank you.
Mr. Zansberg, you have a little over 10 minutes for rebuttal.
Thank you, Your Honors. I'll begin by saying that Justice Hood and others have asked what procedures the respondent is asking be the bare minimum for rendering a proceeding quasi-judicial. And I don't believe any actual, other than adversarial and testing of testimony. Of course, below, the Court of Appeals invoked all of the procedural rights of a criminal defendant at trial under the Sixth Amendment to the Constitution of the United States. That would be, for the Court of Appeals, the bare minimum required to render a proceeding quasi-judicial in nature. Time and time again, as I've said, this court has extended absolute immunity to governmental officials and privilege to people involved in proceedings, including witnesses in the case of Ms. Hoffler and in the case of not Stepanek, Wagner.
So can I ask you about Huffler, Mr. Sandsberg? And good morning.
Thank you.
So in Huffler, we did make a passing reference, I think, to Cherry Hills, and I think we refer to it as establishing the essential characteristics of quasi-judicial activity. But we really seem to focus on the procedures that were followed there. I think that was a DOC disciplinary hearing, if I remember right. But we talked about, if I'm recollecting correctly, the fact that it was subject to direct judicial review, that it was adversarial in nature, that the employee had a right to be represented, to present evidence and cross-examine adverse witnesses, and that the hearing officer had made written findings of fact and conclusions of law. That sounds a lot like what your friends on the other side of the aisle are asking for. So what's your response to Huffler, or how do you read Huffler? And that's a similar question as the one that I asked a moment ago to Respondents' Counsel.
Yes, I read Hoffler as it says in a footnote, reversing only the portion of department against state. Hold on, I have Hoffler here. Only to the extent that the holding of Hoffler, as this court referred to it in People v. Coverman, is, quote, we hold that the doctrine of common law privilege that grants absolute immunity, really privilege, to witnesses in quasi-judicial proceedings does not bar disciplinary proceedings brought against a state employee who makes false statements in the course of an official investigation. That's the holding. The court could have assumed that her statements were absolutely privileged, as was the case in State Department versus Department of Personnel, which earlier had said that disciplinary sanctions, Department of Administration, State Department Personnel, that disciplinary sanctions against a public employee that occurred in a 731 informal discussion, no hearing, no testimony, nothing sworn, no cross-examination, was absolutely privileged. The only portion of that holding that Hoffler reverses is that, as in Stepanek, there are alternative non-tort civil remedies available that still apply. Absolute immunity, as it's referred to here, or absolute privilege, only extends to preventing the types of claims brought here, civil tort claims. They do not extend, that privilege does not extend, as in Stepanek, to Rule 11 challenges, as in Hoffler, to disciplinary actions, as in the Title IX proceeding, to get to Justice Hood's question, the Code of Conduct published by Jefferson County School District says that students who lie to school officials as part of any investigation are subject to discipline. So, yes, had the respondent sought to have what she claims are knowingly malicious false statements, which obviously we refute, but there was an alternative remedy not barred by absolute privilege within the confines of that proceeding.
I'm guessing Ms. Pello would see that as asking the fox to guard the hen house, right? Given everything she described. So is that a meaningful remedy?
It's
a remedy.
Exactly. And there are a lot of other remedies that are available that may not give rise to sanctions. There is a remedy for perjury that she sought, or rather her client sought, to have the witnesses at the criminal trial, a judicial proceeding, absolutely privileged, prosecuted for perjury. And yeah, fox guarding the hen house. It's because they had put together a case that had no basis whatsoever. In any case, it's the availability of a remedy, not whether or not it's actually. Can you
talk about the civil remedies too? I mean, you alluded to that earlier. Respondents' Counsel seemed to suggest it's Pellew, right? It's Pellew. Ms. Pellew seemed to suggest that really wasn't an avenue for them. You seem to disagree.
I'm sorry, the civil remedies against her, other than against the...
But let's take her at her word. She's lived this. She's outraged, obviously, Ms. Palou. We're not as close to it, so...
Sure.
Maybe her outrage is misplaced, maybe it's not. But let's assume for the moment that her client was unfairly rendered a pariah and, unfairly stigmatized, suffered damages as a result, reputational harm and the like, and maybe psychological harm. Certainly if she's correct in her outrage, all of that would seem to be true, right? So what's his recourse, in the civil context? Sue for due process, and that's the avenue? Is that what you're telling us?
The respondent here availed himself of has extremely zealous counsel, and unquestionably so, and availed himself of numerous remedies, including getting the finding of violation of a published policy by preponderance of the evidence overturned, notwithstanding documentary evidence that he sought sex unsolicited from people he'd never had any interaction with before. That alone violated the Title IX policy. That was part of the original finding.
You're diving back into the facts, and I'm
Right.
trying to pull you out of them and say, okay, let's assume for the moment that he has suffered these things. What is his civil recourse?
Well, he sued in federal court and received a monetary settlement for a violation of his rights of due process, which were not violated under the federal Constitution, because Goss versus Lopez says no more procedure is due for a 3-day suspension than the respondent received. So he
brought it. Time is short. So he brought a 1983 action, and it was settled.
Yes.
Okay, so I think that was the question.
I'm sorry.
So he can't bring tort claims here, but he had a 1983 remedy. He had an administrative remedy to challenge the procedures. It could have brought complaints against your clients for perjury under the code. Those remedies were available.
The point being that he's not left high and dry here in terms of seeking some vindication of his interests.
No, he obtained a clean rescission of the finding of Title IX violation, despite unquestioned, unrebutted documentary proof to the contrary, and he received a monetary settlement after filing suit in federal court, and he was vindicated he was acquitted in the trial, which has nothing to do. But with respect to the Title IX, yes, he had available to him an additional remedy to seek discipline under the school's disciplinary code, the code of conduct that he was found to have violated, and then rescinded.
Can I come back to Justice Moore's question, because
Yes.
time is so short? I'm not sure you fully answered where he was at on Hoeffler. So Hoeffler starts with, in Cherry Hills, we identified the essential characteristics of quasi-judicial activity, quotes Hoeffler, quotes Cherry Hills, then goes on to talk about here were the procedures in this case. And I think what Justice Moore was asking was, it seemed Hoeffler said, here's the 106A4 standard, and then starts talking about the procedures, which would suggest that we look to the procedures to see if the proceeding was quasi-judicial. And I guess the question is whether you agree with that.
I don't believe that was necessary to the holding, and I don't believe...
I understand what the holding is, but so maybe it's dicta, but there's a lengthy discussion about here were the procedures afforded to Ms. Hoeffler.
Right. I don't believe that could be read to mean these are the minimum requirements to render a decision quasi-judicial in nature. And it would fly in the face of all of the cases cited in Hoeffler, in which there was no cross, Stepanek and Sternholm, where summary suspension without any right to any hearing whatsoever. I would just, since other counsel had more time granted, I would close by asking the court to look at two things. In terms of the record that was laid out about absolute purity of the actions, I would point the court to page 7 of our opening brief and all of the record sites there that to look at those record sites to see whether or not those representations are accurate. And lastly, Picton versus Anderson versus Union High School District that is cited on page 40 of our brief from the California Court of Appeals. Quote, defamatory statements made in both judicial and quasi-judicial proceedings having some relation thereto are absolutely privileged because this privilege is needed to assure that the utmost freedom of communication between citizens and public authorities whose responsibility it is to investigate and remedy wrongdoing. We ask that the court reverse the Court of Appeals decision below. Thank you.
No further questions. Thank you. The court thanks both counsel for your arguments today. This case will stand submitted and the court will be in recess for 15 minutes.